Welcome to the YouTube channel of Legally Trust. This video is one of the series of educational videos that will be available on this channel under the category General Awareness.
Hello friends, in today's video, we shall discuss on minimum size requirements and minimum shares in public hands. Let us understand what are the main requirements. The requirements for the listing of Indian depository receipts by foreign companies in India are different from the requirements for a listing of shares of a domestic company. IDRs or Indian rupee denominated depository receipts issued by a local depository and represent a proportional ownership interest in a fixed number of underlying equity shares of the issuer, as determined by the issuer. Equity shares underlying the IDRs are deposited with an overseas custodian who holds the share on behalf of the depository. An issuer proposing to list its IDRs on a stock exchange in India must, among other things, be listed in its home country for at least 3 immediately preceding years, not be prohibited from issuing securities by any regulatory body, have a track record of compliance with the security market regulations in its home country, not have any fugitive economic offender as a promoter or a director. The issue is subject to following conditions. At any given time, there can be only one denomination of the issuer's IDRs. The issuer must ensure that the underlying equity shares against the IDRs or issued have been or will be listed in its home country before listing of IDRs on the Indian Stock Exchange. The issuer must ensure that the underlying shares of IDRs rank pari passu with the existing shares of the same class. The issuer must also apply to one or more stock exchanges to seek an in-principle approval for listing of the IDRs and select one as the designated stock exchange. Enter into an agreement with the depository for dematerialization of the IDRs proposed to be issued. Make firm and verifiable financing arrangements for 75% of the stated means of finance for each of the projects proposed to be funded from the issue proceeds, excluding the amount to be raised through the proposed issue of the IDRs or through existing identifiable internal accruals. Not use more than 25% of the proceeds of a fresh issue for general corporate purpose as stated in the objects of the issue in the offer documents. Minimum size requirements. An IDR issue must have a minimum size of 500 million. Minimum shares in public hands, free float. There is no minimum public shareholding requirements for an IDR issue. Now, let us understand the main ways of structuring an IPO. An IPO can be structured in one of the following ways. A fresh issue of securities, an offer for sale of securities by existing shareholders of the company, a combination of both. A company can undertake an IPO either through a fixed price issue or a book-built issue if it fulfills the eligibility conditions. Then, what are the main ways of structuring a subsequent equity offerings? A listed company can raise additional equity share capital in a number of ways under the SEBI Issue of Capital and Disclosure Requirements Regulation 2018, which is commonly known as ICDR regulations, and the Companies Act. The main ways of structuring a subsequent equity offerings are further public offer or follow an offer. An already listed company makes either a fresh issue of shares or convertible securities to the public or an offer for sale of the shares held by its existing shareholders to the public. Right issue. A listed company makes an issue of the shares or convertible securities to its existing shareholders as of a particular date fixed by it, that is, the record date. The rights to subscribe in the offerings are given in a particular ratio to the number of shares or convertible securities held as on the record date. Composite issue. A listed company issues shares or convertible securities on a public cum right basis where the allotment in both public issue and right issue is made simultaneously. Bonus issue. An issue of shares by a listed company to its existing shareholders without any consideration based on the number of shares already held by them as on a record date. The shares are issued out of the company's free reserves or shares premium account in a particular ratio to the number of securities held on a record date. Private placement. An issue of shares or a convertible securities by a listed company to a select group of persons not exceeding 200 and which is neither a rights issue nor a public issue. Private placements of shares or convertible securities by listed issuer can be of three types. Preferential allotment. An issue to a select group of identified person, the issuer is required to comply with various provisions which among others including pricing, disclosure in the notice, lock-in and so on, in addition to the requirements specified in the Companies Act. Qualified institution placement, that is nothing but QIP, an issue to qualified institutional buyers as defined in the ICDR regulations, equity shares, non-convertible debt instruments along with warrants and convertible securities other than warrants can be issued in a QIP. Institutional placement programs, that is nothing but IPP, a further public offer of equity shares or an offer for sales of shares by promoter group of a listed issuer in which the offer, allocation and allotment of such shares is made only to QIBs for the purpose of achieving a minimum public shareholding. Hope this video was informative. Thank you for watching.
Hope the information contained in this video was useful to you. We look forward to each one of your support and cooperation in making this initiative a success. For more details about the trust, do visit us at www.legalaidtrust.in. Kindly subscribe this channel and click on the bell icon to get the latest updates about various law-related educational videos. Thank you for watching us and have a good day.